Gentlemen, if you can take your seats, we'll start. The next speaker is Michael McQuaid, who is one of the leading experts in municipal law, Planning Act law, and who comes to us from a firm that is leading in that field, the Weir and Folds firm. Mike McQuaid, as you all know, practices in an area that very much affects most of our practices to a greater or lesser degree, and he is in front of the municipal board and other related agencies nearly all of his time. He has just come from the Niagara region hearing where he's been for about 11 months. I gather that has been recently concluded, and it of course dealt, as he told me a few minutes ago, with the area of the disappearance of farmland and the various conflicting interests that arise there. Michael has given numerous talks on this subject to Canadian bar and continuing legal education groups, and we're very fortunate to have an authority of his qualifications. Michael?
Thank you, Burke. Ladies and gentlemen, it has been my pleasure and challenge to have been asked to lecture in this general series on the specific topic of remedies in municipal and planning law. And in doing so, I propose, because of the time limitations, to comment on three main areas and to review cases in three areas. The first being cases involving interpretation of bylaws, bylaws, of course, being the heart of municipal actions. The second, some cases, and I'm going to comment on John Nelligan's case, which is winding its way through the courts, cases involving actions against municipalities or other agencies for damages where they may lie. At the outset, I warn Mr. Nelligan, remind him that the famous case of Donahue and Stevenson got to the House of Lords, but I don't think it ever got any further in terms of actually being tried. The third area that I propose to comment on this morning are some review of some cases involving what we would call extraordinary remedies, the old-fashioned remedies, as Mr. Nelligan referred to them, mandamus, and so on. Now, starting at the outset, I would just like to read to you a comment that Mr. Justice Steele put in one of his lectures some many years ago when, in the 1956 special lectures, when he delivered a lecture. At that point, he commented on the fact that urbanization throughout Ontario had resulted in a tremendous increase in the powers of control given to municipalities. And he went on to say that the time was past when a man may consider his home as his castle, or that he has the right to do as he wishes on his own lands. And that was in 1956. Since that comment was made, we have had literally an avalanche of legislation establishing further controls, exercised not only by municipalities, but indeed by provincial governments, by governments such as Metro Toronto and regional governments. Now, depending on the perspective of the person that runs into these controls, they may be referred to as, they're introduced by politicians as the protection of the public interest, by the great majority of people who do not come in contact with these particular controls as red tape, by those who wish to avail themselves of the red tape when they're confronted with an issue as protection of their local neighborhood rights, and by academics and lawyers as interesting examples of administrative law and due process. Now, remedy is defined, generally speaking, as a form of redress or relief, or a means of counteracting or removing an evil or a problem of any kind. And the obvious question in the area of municipal and planning law, given the legislation which has been introduced, is whether the remedies available to people encountering these controls, whether they be ratepayers coming in contact with their municipal representatives, or people affected by the actions under those controls and legislative actions, whether those remedies have kept pace with the legislation that has been enacted. And Accordingly, I would like, as I say, in the first instance, to approach the issue of whether or not bylaws and municipal actions and the views of the courts with respect to those bylaws have altered over the period of time that the legislation has increased. Now, municipalities are generally required by law and statute to exercise their municipal duties and rights by bylaw. Occasionally, there are direct powers given to agents by the legislature, but as a general rule, it is a bylaw enacted pursuant to Section 241 of the Municipal Act that gives the council the duty or the ability to exercise its powers. And as I said earlier, the bylaw is therefore the heart of any municipal action, whether that action be contract, administration, planning, or any of its other legislative functions. So accordingly, it's normal when you are confronted with a situation and when you are examining a client's plight to look first to the bylaw upon which the municipal action is founded in order to determine whether it has or is a valid exercise of municipal legislative authority. Now, the validity of a bylaw, of course, as you know, can be tested by motions to quash under Section 283 of the Municipal Act, by an application for judicial review, or by an action by way of writ for a declaration as to the invalidity of the bylaw. Occasionally, it may be in the client's interest to take a defensive position and wait until a charge has been laid or an injunction has been issued before questioning the bylaw. Often a direct blow at the bylaw may avail or give the client all of the relief that he requires, but increasingly it would seem attacks on bylaws are combined with some other form of relief, an application for a mandamus or a declaration, and increasingly we see the combination of a motion for judicial review, questioning the bylaw, and asking for other forms of relief. One area that I'd like to comment on briefly is the court's views on interpretation of bylaws. And in doing so, I bring to your attention a comment of Chief Justice McQuaid based on decisions in the Court of Appeal in the early 1950s. There he said in Bridgman and the City of Toronto, there are certain cardinal principles that are never to be forgotten with respect to cases of this kind, with respect to all matters that the courts have to deal with affecting property rights. And he then went on to describe how bylaws should be given absolutely strict construction because they are restrictive in nature on the liberty of the subject or the liberty that he may have in exercising his rights over his own property. Now that was in the early 1950s. But by 1971, the wheel had turned full circle, and in Bruce and the City of Toronto, the Court of Appeal, in dealing with a mandamus application and the interpretation of a City of Toronto bylaw, went on to state that the bylaw was enacted to enhance and preserve the quality of life in the municipality and the amenities considered conducive to the health, safety, convenience, and welfare of the inhabitants. Accordingly, I consider the bylaw to be remedial and one to be accorded a liberal interpretation to the end that it may afford the people of the community protection and so on. And we had then the introduction of liberal interpretation, and then subsequently, shortly after, in the Supreme Court of Canada, Mr. Justice Spence returned the question of interpretation to a rather neutral position when he commented on Bruce and the City of Toronto and indicated he approached the interpretation without acknowledging any compulsion to consider its provisions either strictly or liberally, although he made or isolated the Bruce case to applications where there was an encroachment seriously affecting a residential neighborhood. All of which suggests that on any individual situation, you may presumably cite the neutral, the strict, or the liberal interpretation. Now, in terms of examination by the courts of bylaws, there are three areas that I will briefly touch upon. The first is declarations or motions to quash based on illegal or ultra vires bylaws. All of us are familiar with the examples such as Morrison in the City of Kingston. We are taught in law school where Kingston tried to prohibit slot machines, and that bylaw was quashed because there was no specific power in the Municipal Act to permit the enactment of such a bylaw. And recently, we've seen an example in the Ontario reports in Weir versus the Queen, where the City of Toronto unsuccessfully was able to resist an attempt or an application to strike down its anti-smoking bylaw. Another common area that has been appearing, and this I think is an example of the expanding power of municipalities or expanding interest of municipalities, and perhaps of the other forms of government as well. But there are an increasing number of cases, such as Orangeville Airport in the town of Caledon, where municipalities have attempted, in that case, to zone an airport, and the bylaw was invalidated because its subject fell within Section 91 of the British North America Act. In an unreported decision recently issued by Mr. Justice Craig, the same principle was applied in the town of Grimsby and Rogers Radio, where the town of Grimsby attempted to prevent the erection of antenna that had been approved by the CRTC in Ottawa. Mr. Justice Craig found the zoning bylaw prevented that facility being erected, and the bylaw was quashed on a motion to quash. But the more recent attacks on bylaws have involved a more sophisticated examination by the courts, not just of what's in the Municipal Act, or not what is in the federal provincial BNA Act, but rather what the authority in the enabling legislation was supposed to permit or allow the municipality to enact. And an example that I've referred to in the paper, and I'll briefly touch on, is the regional municipality of Ottawa-Carleton in the Township of Marlborough case. There, the Township of Marlborough took a series of 1 foot dedications by resolution. That had the effect of creating something in the excess of 100 building lots and avoiding the Land Division Committee or the subdivision process under the Planning Act. And Mr. Justice Lecourcier, at that point in the trial level, struck down the resolutions, and in his particular judgment made a number of comments indicating that he was looking at what the Planning Act was going to permit the municipality to undertake. At page 305, he makes a very interesting comment that a bylaw must be passed for the purpose allowed by the statute, and the council must not seek in enacting a bylaw to accomplish indirectly that which cannot be directly accomplished in the manner provided by the legislature. The judgment and its reasons are noteworthy because of that comment that I've just made, because it introduces the concept of judicial examination of the actions against the purpose of the enabling legislation, and also because that wording about preventing municipalities from doing indirectly what cannot be done directly echoes a comment of Lord Denning in a case in the United Kingdom, Laker Airways and the Department of Trade. It's referred to, and I've discussed it in my paper. An interesting, but unfortunately rather long case, one of those cases in the All England reports which seemed to take half of a volume. But in that particular case, Sir Freddie Laker had initiated his SkyTrain service and received the approvals which would allow him to start the service between New York and the United Kingdom. But there was a change of government, and the new Secretary of State said, or issued a guidance or white paper indicating that the service was going to be canceled. And the matter went to the Court of Appeal, and in the course of examining whether or not the prerogative of the Secretary of State could be quashed as being ultra vires, Lord Denning raised the question of raised the question of whether the Secretary of State could withdraw the designation. And he said, can he do indirectly that which he cannot do directly? Can he displace the statute by invoking a prerogative? The Court of Appeal went on to indicate that although prerogative generally had not been touched by the courts, in that particular case, the prerogative decision was set aside. And the Laker Airways case has been recently followed by the Divisional Court in an unreported decision of the City of Peterborough and the Township of Smith, and I'll comment on that a little later in my lecture. And I've also set out in the lecture other references to this principle of declaring a bylaw ultra vires in the British Columbia Court of Appeal, and we see a more recent example in Bell versus the Queen in the Supreme Court of Canada, where the bylaw in North York, which attempted to define family in a zoning bylaw, the Supreme Court of Canada found that there was no direction from the legislature which would have allowed that definition of family to be thought up or legislated by the local municipality. The decision is also interesting because the court introduced a concept of quashing a bylaw for unreasonableness in spite of the direct wording of Section 241(2) of the Municipal Act. There is now a concept of a bylaw being so unreasonable that it goes outside the stricture in the Municipal Act, which says no bylaw can be passed for being unreasonable. Turning then to a second area of questioning of bylaws, that is bylaws and their declaration or their possible invalidity on the basis of bad faith. In the paper, I've brought to your attention the H.G. Winton case, a case in North York, where the Divisional Court quashed a zoning bylaw on the grounds both of discriminatory and of bad faith. That involved the sale of the house of the famous author Mazo de la Roche to the Zoroastrian Society. The Zoroastrian Society wanted to locate a church. They went to North York, found that churches were permitted in an R3 residential district. The Zoroastrian Society is a religious group based on a religion founded in Persia in the late 7th or 6th century BC and practiced by the Parsis in India. Well, after the neighbors had heard that this famous mansion was going to be used for the Zoroastrian meetings and church group, they went to the council, raised the alarm, and a very quick bylaw was passed eliminating church uses from this R3 zone. And the case is very interesting in the sense that Mr. Justice Robbins, who wrote the decision for the Divisional Court, in citing the older cases, then went on to apply the facts and in my submission gave a perhaps new indication of what the courts would accept as bad faith. He commented on inordinate speed, the pretense of it being operative on a larger area, setting aside the usual practices, and keeping the parties affected in the dark. All of those things, he said, added up to bad faith, and the bylaw was quashed. Brief comment on bylaws and the failure to give notice. Now, in the planning area, the failure to give notice of a zoning bylaw is not fatal to the bylaw based on Zadravec and the Town of Brampton case. In a series of recent cases in the Divisional Court, Starr in the Township of Puslinch and more recently Maple Leaf Mills and Point Edwards, the Divisional Court has also said the failure to give notice of an official plan amendment is not fatal to that as well. And this is of some considerable interest because there is no requirement in the Planning Act to give any form of notice respecting official plans, and there is great difficulty in knowing, therefore, what is going on at a council insofar as official plans are concerned. But Maple Leaf Mills and Point Edwards has said it is incumbent on any ratepayer in a municipality to monitor the proceedings in the municipality, and the only way they can be sure of getting a hearing is by availing themselves of the rights under the Planning Act and asking the minister who approves the municipal action to refer it to the Ontario Municipal Board. Those cases were based upon the fact that what the municipality was doing in enacting both an official plan and a zoning bylaw, or particularly an official plan, was not the discharge of a judicial function because of the fact that the final action in the planning process was done by the minister or the Ontario Municipal Board. I've also commented in my paper, and I'll just pass over the fact that one other area in which there are at least 3 cases that I'm aware of in which fall under the provisions of the Planning Act, in particular Section 29.3, 29.3 allows a municipality to what we call deregister a plan of subdivision after 8 years. There were a series of cases, Rollins versus South Fredericksburg, unreported case Stoller in Midland, Chartrand in the town of Hawkesbury, which all said a municipality had to give notice before they were going to pass this bylaw to deregister. But recently in the Court of Appeal in Village of Wyoming and Homex, the Court of Appeal concluded that there was no necessity to give notice, and in one comment which I think merits some considerable examination from administrative law professors and persons interested in those areas, the court concluded that the function of the council was purely legislative and no notice was required, and also went on to say it was not unfair of the council to enact this bylaw without notice because the owner had made clear what its position would have been if they'd given notice. And I question whether the audi alteram partem principle would be suspended if the nature of the party's representation would be apparent or known to the tribunal about to make a decision. That, of course, would defeat the whole concept of what the principle stands for. Now, leaving bylaws and turning to the second general area, which I'd like to touch on and which I have outlined in more detail in the paper, and that is the area of actions against municipalities for breaches of statutory duty or negligence. That is where a person comes into contact with the municipality, and instead of quashing the legislative function or the bylaw, which is the area we've just been talking about, where they may be involved in seeking some sort of damages as a result of the municipal action. There's no question the leading case on this particular item is Pugliese and the National Capital Commission, Mr. Nelligan's case, as it is winding its way through, and I've forgotten how many defendants he has up to date, but it's certainly up in the dozens. But this particular case did go to the Court of Appeal, and Chief Justice Howland wrote an extremely fine decision summarizing the main principles of tort in this area. The two main areas, of course, of relief for a plaintiff are either by way of breach of statutory duty or by just the law of general negligence. And Chief Justice Howland summarized, and I've set out in the paper, the 4 criteria upon which the courts have generally been reluctant to allow damages for breach of statutory duty. Perhaps a wise consideration or a wise decision in view of the large number of duties that are established by the legislation. However, Mr. Justice Pigeon in the Supreme Court of Canada has indicated that there may be, in this particular case, an action for breach of statutory duty and the provisions of the OWRC Act. The nature of the action, of course, it was a reference under the Judicature Act, under Section 35, so that there has only been a determination of the legal principles, and that then sends it back to the lengthy discoveries and the lengthy trial of the facts, which Mr. Nelligan's referred to. But the other extremely interesting perspective in this decision in the Pugliese case is the fact that the Court of Appeal adopted the Anns versus Merton London Borough Council case, a decision of the House of Lords. Time really does not permit a discussion of that case in any detail, but that case upheld another decision of the Court of Appeal, Dutton versus Bogner Regis Urban District Council. And it is considered that the Anns case is added to that famous tradition or trilogy of cases, Donahue and Stevenson, Headley and Byrne, and Dorset and Yacht, all of which lead to an extension or development of the law of negligence. And what Pugliese has done, in Court of Appeal in particular, has said that it was difficult to see in the general circumstances that the defendant should not have had the plaintiffs in the Pugliese case within their contemplation, and that unless the duty of care was reduced by statute or otherwise, there was a duty to take reasonable care to avoid acts or omissions which one could see would cause injury to the plaintiffs in that case. I've also referred to Wellbridge Holdings and the Metropolitan Corporation of Greater Winnipeg, case of the decision of the Supreme Court of Canada, which distinguished immunity or distinguished liability for municipalities based upon the actions of the municipality, whether they were taken in a legislative as opposed to an administrative or operating level. Both of those cases, Anns and Wellbridge, have recently been discussed in Alberta and Bowen versus the City of Edmonton, and it is obvious that there will be further reference and further actions arising from municipal actions to seek damages based upon public statutory duties imposed on municipalities and the principles set out in the Pugliese case. A very brief comment on another tort that there is development on, but as all principles established by common law, the liability has been subject to an ebb and a flow of judicial interpretation. And that, of course, is the application of the Hedley-Byrne principle to municipal actions. Initially, the liability of municipal employees appeared to be extremely wide, but more recent cases in Canada have suggested that the potential liability is reduced. And in the paper, I have described what happened through the Windsor Motors and District of Powell River case, and in Ontario, the Gadsousis versus Milne case. Both cases where a trial judgment awarded damages because the municipal employee, upon an inquiry from a ratepayer, had failed to give the proper information about zoning. The plaintiff had then acted on that. Subsequently, the zoning was found to be, the information was found to be inaccurate, and an action for damages was awarded or found, the municipalities were found liable. However, in Paw and Porky Packers and Sheridan Builders versus Mahler, the liability of the municipalities have been substantially reduced, and it is necessary to demonstrate that the plaintiff, first of all, did not have as much or more expertise than the person from the municipal employee from whom he was inquiring. And in Sheridan, the court concluded that the municipality is only liable for its own bylaws and not for any information, as in that case, of what the Conservation Authority might have done. So in this area of remedy for damages against municipalities, there has clearly been some development in accordance with the general development of negligence in other areas. I'd like to turn now to the third area that I will be able to talk about this morning, and that is a brief review of cases and the areas of extraordinary remedies. Now, first of all, dealing with mandamus, and no review of remedies in municipal law would be complete without some comment on the remedy of mandamus. But the most notable observation in this area is that the remedy is disappearing as an important remedy in municipal matters. This appears to be because of the provisions of the Planning Act, in particular Section 35A of the Planning Act, which allows the municipality to develop or impose a development control process. That process, in turn, requires the developer to submit plans and enter into an agreement for the provision of certain services. And as a result of that, there is a condition precedent, as it were, effectively precluding the developer from presenting a completed set of working drawings to the building inspector in order to achieve the substantial compliance of plans that the courts have insisted upon in order to justify an order in mandamus. However, there is one case, if you are fortunate enough to avoid the Section 35A problem or that condition precedent, Hall versus the City of Toronto, a case in which the Court of Appeal reviewed the actions of the City of Toronto in a somewhat different light from usual cases and found bad faith against the city in what appear to be very ordinary circumstances. That is, where a developer explained to his neighbors what his project was going to be. They went and asked the municipal council within a day or two to enact what is in Toronto known as a resolution indicating a declaration of intent to zone, a very common technique that's been used in Toronto. That then was used in mandamus applications to resist or prevent the applicant from being able to say that the municipality did not have the course of planning program, which is one of the principles enunciated by Mr. Justice Spence in the Boyd Builders and City of Ottawa case. Well, the interesting thing in Boyd is that they found that the combination of this immediate or snap action on the city, together with the failure of taking the interest of the appellant into account, was or amounted to bad faith, and in that particular case, a mandamus was, or an order was granted. Turning briefly again to injunctive relief, the other form of extraordinary remedy which is common in municipal matters, I would refer you to the Campo versus the Region of Ottawa-Carleton case. Now, in that particular case, it demonstrates what we are likely to see because of the split jurisdiction in zoning matters established by reason of regional and local area municipality government. In the Campo case, the town of Gloucester was about to issue a building permit for a shopping center in accordance with its approved zoning bylaw. It had the zoning bylaw in place. However, the regional municipality of Ottawa-Carleton had enacted an official plan in which they had designated this land as residential. Now, normally we have thought of official plans as not being restrictive of land user, but under the Regional Municipality of Ottawa-Carleton Act and under other acts establishing regions, the local municipalities are supposed to amend their local area bylaws forthwith upon the approval of the regional plan. And what happened in this particular case was that an application was brought for the injunction, and both the trial level and the Court of Appeal concluded an injunction should issue to restrain the issuance of a building permit for the construction of the shopping center, even though it was permitted under the local area zoning bylaw. As a result, it now appears that where local official plans of regions are in place, a ratepayer or any other person interested may be able to demonstrate that the regional official plan has, in effect, repealed the local municipal bylaw, if they can bring themselves within the time period that the courts might consider as that which the township should have amended forthwith its local area bylaw. I know that in Metro Toronto, for example, they've recently approved a policy that all development shall have a minimum of 15 units per acre before a plan of subdivision shall be approved. Now, what this means is that any local municipality who processes an application for a subdivision and does not meet that particular requirement will be met with the fact that the Metro Toronto plan, being the senior level plan, will prevent any lower density than that particular plan or that particular project. And the result, of course, is that the senior level of government is in the business, depending on the wording of the local regional official plans, is in the business of local zoning bylaws. An area heretofore they've left to the local municipality. Dealing with declaratory relief very briefly, I have referred to an unreported case of the city of Peterborough and the township of Smith, an example demonstrating the fact that declaratory relief and what can be sought therein is, of course, limited only to the ingenuity of the applicant in the circumstances of any case. In that case, the city of Peterborough was successful in an application to quash a building permit issued by an adjoining municipality, the township of Smith. And the circumstances are not totally unusual, but there had been an Ontario Municipal Board hearing at which both municipalities had gone to a hearing to determine who should get the location or be approved for this shopping center. The result was the township lost, but then turned around after having appealed to the Court of Appeal and to the Cabinet some 6 or 7 months later and issued a building permit saying, oh, we reread our zoning bylaw and found we didn't even need to go through the process. In that particular case, the matter was taken to the divisional court, and as I alluded to earlier, the divisional court declared the building permit null and void. Relief was sought, among other grounds, that the actions of the township were illegal, and I direct your attention also to the fact that there was an allegation that the township was stopped or otherwise prohibited from issuing the permit. And as I indicated, the Laker Airways and a number of the cases which I have referred to earlier were relied upon by the divisional court. They said as well that the township did not act reasonably or in good faith and sought to do indirectly what it had been precluded from doing directly. A building permit issued in the circumstances of this case should not be allowed to stand. And that leads me then to a final area that I'd like to just bring to your attention, where there appears to be some development, and it's of considerable importance in municipal matters. And that is the issue of what we have generally referred to as estoppel. Now, the general principle has always been that there can be no estoppel against the Crown or any other governmental or public entity, including a municipality. And the reason for that is that there was concern of the courts that bringing in the doctrine of estoppel would infringe upon that agency's legislative function and would defeat the operation of the legislation. However, there appears to be a developing body of cases which, without specifically invoking estoppel in some of the cases, in others they have referred to it as estoppel, they have come to the same result in many respects. What underlies the court's views in these cases, in my submission, is that the courts are making a distinction between an intrusion into the authority's policy-making function and an expectation that tribunals and municipalities should be bound by their own assurances and undertakings as to how that tribunal will conduct its actions. It's a form of proprietary estoppel, in a sense, or promissory estoppel, depending on the circumstances in the case. And the justification for invoking this type of quasi-estoppel is that the undertaking or insurance that's given by the municipality or the tribunal really is not incompatible with its public duty and therefore not destructive of the operation of the legislation. The starting point, again, for this development is the irrepressible Lord Denning. In Lever Finance versus Westminster Corporation, he held a municipality was bound by a planning officer's decision that the variation of a site of a house was not a material variation, and he, in commenting on estoppel, said, "I know there are many authorities that say a public authority cannot be estopped by any representations made by its officers, but those statements must now be taken with considerable reserve." And he went on then to in fact hold the corporation to the statements of that planning officer. In R versus Liverpool, the Court of Appeal in England was faced with an argument that a local authority could not be made to abide by an undertaking that the parties would be heard. And Lord Denning in that case again distinguished between a governmental authority being estopped in performing its legislative duty as opposed to being held to the performance of an undertaking. Again, in Laker Airways, while the case did not turn on the concept of estoppel, Lord Denning went out of his way to raise the issue of whether there ought to have been estoppel against the Secretary of State, and he then gave a paragraph which I've set out in the note indicating there are circumstances, although this was not one of them, in which the municipality or a tribunal, you can say municipality, but a tribunal can be estopped when it's not properly exercising its powers, but is misusing them. Now, the Liverpool Fleet Operators Association case was relied upon for the first time in the Court of Appeal, and we believe in Canada, in Multi-Malls and the Minister of Transportation and Communications. In that case, the Court of Appeal relied upon the Liverpool case and said that the Liverpool decision, which Mr. Justice Lecourcier indicated had not been considered in any Canadian case, imposed on the minister, in accordance with natural justice, if not by estoppel, the duty not to give approval to the unmodified official plan without referring the matter to the municipal board for a public hearing. Again, as I note, the issue of estoppel or an extension thereof was raised as well in the city of Peterborough and the township of Smith. It was not discussed in any detail, but the Laker Airways case was cited, among others, as justifying relief for the city of Peterborough in that case. I've also refer you to a detailed and excellent discussion of this estoppel against governmental authorities, which is found in the Osgoode Hall Law Journal an article by Mr. MacDonald on contradictory government action and estoppel against statutory authorities. He has concluded that, in fact, in other cases throughout Canada, including Smith versus Vanier, a licensing case, that the courts have been using and developing a concept of what we would refer to as quasi-estoppel. Now, time does not permit any other areas. I have commented in my lecture on some developments before the Ontario Municipal Board, keeping in mind that rather broad definition of remedies and relief for evils, problems that are posed. And in the case of the Ontario Municipal Board, I've commented really on the case now before the Supreme Court of Canada, Township of Innisfil and the Township of Vespra, and how the issue that is increasingly appearing before the Ontario Municipal Board, that is how government policy, usually in the form of a letter from one of the affected ministers, is sent to the Ontario Municipal Board, how that particular government policy is to be dealt with. The Court of Appeal in Ontario has, in the majority, said that the letter did not found or could not be used to cross-examine the policy that was contained and stated by the government therein. The majority said that no cross-examination should be permitted. Mr. Justice Blair dissented and thought there should be a cross-examination on the policy by an officer of the ministry that wrote the letter. But the Court of Appeal was unanimous in concluding that the board erred in saying they were bound by the policy and they would not hear evidence or argument by the objectors on that policy. But the matter is now before the Supreme Court of Canada, and we have to await the final determination. I've also commented on one other area increasingly before the board involving levies, a very common type of hearing which is taking place involving the imposition of the duties and levies in planning and zoning matters. In conclusion, I'd just like to get back to the point I made earlier in the lecture when I referred to the avalanche of legislation enacted over the past few years granting increased power to municipalities, ministers, and other tribunals. Now, as a rule, decisions made on planning matters, of course, are referred to the Ontario Municipal Board, where, to the board's credit, most matters are resolved, and there are very few appeals to the courts from the decisions of the Ontario Municipal Board. There are increasingly more appeals to the Lieutenant Governor and Council, to the Cabinet, and attempts have been made to determine whether there is any control over the manner in which those particular petitions are dealt with. But the Divisional Court has, in a series of cases, indicated that while it's a judicial body, it can act politically in whatever manner it can, and it's beyond the court's purview. This lecture is not really attempted, other than highlighting a couple of areas, to discuss the principles now before the board or the courts. I have attempted to discuss those cases involving actions for damages based on municipal actions, but in most cases involving municipal action, an action for damages really will not restore the justice that the aggrieved party seeks, because the decision may have been made wrongly. In that area, remedies must be devised to assist the individual or group who seek redress from an administrative act wrongly made. As Professor Wade says in his text, and as I'm sure Professor Evans will leave in the text, rights depend upon remedies. And in our tradition, the courts have been inventive and resourceful, as you heard Mr. Nelligan speak earlier, in the area of negligence, in extending and adopting the common law remedies from one form to another as circumstances have required. But in order to allow that process to occur, we lawyers must prepare the briefs based on the facts that are presented to us, develop the briefs, and argue the principles which start the process in motion, which will allow the courts to develop the principles that the plaintiffs and aggrieved parties seek in order to obtain redress. It's my hope that this review of some of the recent cases in the field of municipal and planning law involving remedies will assist you in that important process. Thank you.